What do you do if you're going into a marriage and you find out that your soon-to-be spouse has hundreds of thousands of dollars in student debt, student loans, things like that? That's an issue that comes up a whole lot in a lot of these cases is student loans. Almost everybody's got a student loan these days, and student loans are often some of the biggest substantial debts right after a person's mortgage. So how do we handle those? If the debt was incurred prior to the marriage, it's going to be presumed to be a non-marital debt. That's the good news. However, these things often can get tricky, because sometimes people refinance the loans during the marriage. And if you refinance the loan during the marriage, now it might be considered a marital debt. Now, Florida's equitable distribution statute, allows the judge some leeway. You can make equitable arguments. Equitable arguments means what's fair. Doesn't always mean what's equal, but what's fair. And perhaps you can make an argument that an unequal distribution of the debt would be more appropriate in light of it being a student loan, but there's no guarantees on that. That's an argument you'll have to make. So it's really critical when the debt's incurred. If your spouse decides to go back to school during the marriage and you take a student loan for that, then that's probably going to be a marital debt. So these are all things you need to keep in mind when you're thinking about family law and student loan debt, and it's something that you need to be mindful of when the debt was incurred.